using video games to contextualize law and technology. And in this, I'm just going to run through of what kind of the approach of the paper, the idea, what I was looking at. I've always kind of been a fan of using non-traditional sources for helping to contextualize information because at times law can be quite dry. I know from contract law as an example, I know students can kind of wonder why we're still dealing with cases from the 1800s and sheep being washed overboard, or tort law about sheep being left on a dock. There's a lot of cases about sheep. So it's kind of just helped to recontextualize it. And I thought it'd be fun to try use video games this year because students, they deserve a break, and I think it's great as a great reason to be using the videos, but also have some tangible benefits. So it's not just them playing Call of Duty or FIFA or Helldivers 2 for a couple of hours. There is some tangible benefits, but also if they have parent, or for example, they're living with their parents, they can say, "I'm doing this for research," so they have that bit of a carve out for themselves. So I've assigned this as an to my law and technology class. It's a third year elective, and I've roughly 70 students across two cohorts. And I've assigned them to play a video game to help them to recontextualize and place the idea of law and technology in a real world context, because we were dealing with a lot of high level abstract ideas. What is data? What is the concept of privacy? And I thought this assignment would help them bring it back down to the everyday context. And the assignment was they had to write a reflective journal using video games to kind of put into place their thoughts and gather it in their own words. And that's kind of like the scope of the assignments. And then there were some risks and liability I was going to talk about at the end of what I have to do to be careful of assigning video games, some of the criteria of it, and the students' stage from a pedagogical point. So you can see video games. The argument is video games are the most ancient vehicle for education. They are the original and natural education technology. So I thought because of this, why not go back to the basis? Look and use video games as a tool to supplement legal education teaching, but it's not replacing, because for the core compulsory modules, there are elements you have to know. You have to know the 5 essential elements of a contract. But for some supplemental tools, I thought, why not look at how contracts work in relation to technology? Why not look at them how they work for video games? Because students who are using technology would have signed dozens of contracts, the user license agreements that they may not have read, and just looking at where this kind of takes place. And numerous studies you can see there have confirmed the effects of video games on cognitive and social and environmental adaptability, defined broadly as the manner in which an individual interprets and responds to different situations. So this is just drawing on different sources, because where we have the black letter of the law, there is a push and move towards socio-legal research, quantitative and qualitative research, and drawing in the wider effect of society and law. So again, it's a tool that can be used. It's a tool that is kind of present in the student's everyday life. As a tool that as a means to instruct or impart a lesson. And video games have clear learning instructions and learning outcomes across a wide variety of learning styles. So it does kind of reflect the pedagogical approach of how do we teach students, that there's not one type of student, there's not one correct way to teach. So we can do it through practice, we can do it through repetition, we can do it through a Socratic method, and just using video games as a way to kind of put these lessons in context. So looking at the specific engagement tools and the specific mechanisms of a tutorial level, and where we have a tutorial level, it can quite easily to a tutorial itself, both in name and nature, where we're helping and guiding students. And the learning outcomes kind of do overlap. That there's the informal, we inform the learner of the objectives. What are we doing in the tutorial? We stimulate recall of prior learning. We can ask students, what have we done before? We present stimuli material, problem questions, case questions, prompts. We provide learning guidance that we have in tutorials in legal education. We ask them questions. We have a structure. We provide readings rather than just telling the students, go off and read all of the law. We have a list of performance feedback and assess performance. This is just running through the class, running through the assessments, and video games and tutorials have enhanced retention and transfer of knowledge. That if the students can put it in their own words, if they can explain it back to you, it shows they've learned it. And this is what I was looking at in the assessment, where I've asked the students to write a reflective journal. And as part of this, excuse me, I stressed to them that this isn't a research assignment similar to previous essays you might have done for your first year or second year or any term exam. This is about placing it in a context in your own words, stressing to them that they don't need to worry about citation for this assessment. So I don't kick open that hornet's nest for the exam word, but it's just how they know it, how they can be talking about it in a slightly more informal approach. I phrase it as a journal or a journal entry type piece, and students were they were kind of responsive to this. Some had queries and some had challenges of how they couldn't adapt to this format, but they kind of knew what they needed to do. But it's just crossing the T's, dotting the I's, making sure they could still get good grades, and kind of making sure their performance was correctly assessed. So I found it as a useful tool, and using video games for this. Like video games, you can, when you do well at it, you can progress to the next level. When you do well in your exams, you progress to the next module or year, and there is a bit of a reward for it. So video games have been used a bit in legal education. Just some studies there where they have been used as a narrative tool in higher education. And across these topics, they have looked at them for reflection of general law or areas of international humanitarian law or laws relating to conflict. And this could be part as a result of the nature of video games, where for a large part, they may have a violent component or it's commentary about the violence, or immigration law, where there is a specific game where it can be done. But for the question of law and technology, there's no one kind of perfect video game to apply the principles of law and technology, but applying the use of all video games may be appropriate. And that's kind of what we were looking at. And in the study, in this assessment, I was kind of looking at what can we do with this? What is the requirement for this? It is, how can I use a video game to kind of help students understand the principles and topics that we were discussing in class? And there are a number of benefits here that video games are at the core of creative endeavor, and it does help students think. It does help them engage with the elements that we kind of touch on in class. You can see there that the various components to create, encompass, and engage with the video games can serve as a microcosm for the wider areas of law and technology. We looked at intellectual property a little bit. We looked at the idea of privacy. We looked at questions of law, society, and ethics. We were looking at these in very not quite superficial way, but just it was an introduction to areas of privacy, of the privacy paradox. Should you have the video game company developers, Steam or the EA store, installing software on your computer to make sure you don't cheat? Is there a trade-off if you want to play competitively on certain esports? What are the IP elements? Can you make your own game? Can you engage with existing cross promotional material or characters across different genres, different formats, or where they're all owned by the same company? We're looking at the idea of how we can use video games as a way to reflect on law, society, and ethics. And the classic example is age rating, and the whole question of should you let a 5-year-old play Grand Theft Auto? And are age ratings appropriate? Are age rates a guide? Is there more strict law behind them? What's the mentality behind it? Questions about censorship of video games as a media. Should this new technology, should you be able to restrict the sale of video games to reflect national law? Where, for example, we talked about in class, on Steam, there are certain games you can't buy in Germany because of restrictions and in relation to Nazi iconography. And should that be allowed? Is that a censorship of the art of the video game, or is it a balance on the national legislation? And we're asking these kind of questions and touching on areas of, like this with the idea of video games as kind of a core component. So video games themselves then have a challenge of how law works. They have the questions about jurisdictional agreements. There are questions about when you're signing a user agreement with a video game to play it, do you have to actually sign it? Do you have to engage with the user license agreement on a product you've purchased? Is there a question of did you buy a product or did you buy a license? There's a question about the moral or author's rights versus the economic rights. This is something we didn't touch on too much. Just the students they hadn't covered intellectual property, so I didn't want to dwell too much on this. But it is something that can be done, of looking at where you have a person's name on a video game. Have they sold the rights to their name? John Madden, for example, or Hideo Kojima, where he was associated with the Metal Gear Solid games, but now he's off creating Death Stranding 2. What is the economic right to use his name or his impact? There's questions about transformative or derivative work, and examples there that we touched on in some of the class of let's plays and creator content and fair use of using a video game. Can you provide reviews? Can you censor reviews that are negative under the guise of intellectual property law? So students were exposed to these elements throughout the module, and we're kind of reflected through the use of video games as a whole, kind of encouraging them to think of them as, they said, media. That it wasn't just a abstract idea of, oh, there could be some media that could be put online, and it could be taken down because the owner and creator of the media isn't supportive of negative views, but we could use them as examples, and they were quite easy to find. This then goes to the assignment where students were asked to actually play a specific video game in light of these considerations. That this was something that we talked about from the very start, that it was going to be their assignment. And one of the elements I had to figure out about this was what kind of video games can we assign to students? What kind of video games would be supportive to students? Because not every student will want to play a video game. Not every student will be able or interested in playing video games. So there was a question of what is the balance between a accessibility game that ticks all the boxes of what you want to look at through the prism of the video game, where there's challenges of law and technology, while not forcing students to have a £4,000 gaming PC or a PS5 Pro. Can they just play it on their phone? What is the idea of accessibility? So ultimately, I opted for Pokemon Go because it was quite accessible. It is a free app that you can download on the Google Play or Apple App Store. It's a low stakes game. It's a low commitment game. It's not the most difficult to play. It is just throwing a Pokeball or swiping up on a screen occasionally. And there is an element of engagement, and it was seen as a low stakes game. And to be honest, it is a fun game as without it becoming a Skinner box or shiny distraction. That it was a low commitment. You could play it for a short amount of time and then put it away, and then remember a couple of months later you have on your phone. As part of the assignment, I said to the students to play it for about half an hour over the course of a month, because I figured that would be a minimum enough time that they have got through the tutorial, they've got through the introduction, they have got a feel for the scope of the game and what they can do, but they don't have to commit too much. So when they're walking to and from to campus, if they're taking transport, if they're parking, if they have 5 minutes to walk their dog, let's say, they could play it there and then, and this could build up over the month. And I did say to students, I do play it myself. It is a fun game, so there is that element of encouragement to play and engage with these processes. The students were then asked to write a 500-word reflection journal about their experiences through the context of law and technology, looking at using how law and technology applies to Pokemon Go. So students were given some prompts or some suggestions that they could look at from a privacy point, they could look at from a data mapping and data generation point, and that was another benefit of the selection of Pokemon Go, that there is a lot of user data being generated and user content being generated, where you go to a Pokestop, for example, you scan a statue, you're scanning that, you're providing more real-time information, you're showing how busy a location may be, weather conditions, the user base, and a lot of information has been sent off to Nintendo and the Pokemon company. So students were asked to consider this, of what is happening with your data. Are you making this trade-off that they can record the information on your mobile phone? And that was the other aspect of having it on their phone, where students have that in their hand. They are very are more aware of privacy-related elements on their phone that they may be on a desktop or a laptop, that they have the phone. They don't want. They're used to seeing questions of, can an app access your contacts? Does a calendar really need to access your message history? So students were kind of aware of that, but applying it through the idea of video game, they were looking at the questions about privacy, the privacy paradox, and the idea of data protection and data consent. And then it's a reflective piece, so it was about putting it in their own experiences and filtering it through the prism of Pokemon Go as a unifying element. That it was, again, a game that they're all playing, and an unforeseen element of this was it did kind of foster a small community of, they were talking to each other about the game, they were talking to each other and trading on the game. I wasn't expecting them to do that. Not that they're disencouraged from communicating with their classmates, but it was just a way to foster a bit more of a community sense, that they were all on this together, they were all playing the game together. The assessment then itself, I stressed it wasn't to play the game, that they're not, and I really did stress that the students, if they are bad at the game or they didn't enjoy it, that's not going to be great, that's not going to be reflective on them. But it was to evaluate the legal principles and approaches of, do you have to consent to use this game? Can you refuse to play this game because you aren't comfortable providing the information or allowing Nintendo to have access to your information? And I did say to the students that if you really do feel uncomfortable with this, come up and talk to me. And one or two had queries about it, of what they have to do, what they can do in this, and it was reflective of this, and allowing for students who have no interest in the game or uh, time constraints, that even if they didn't have that half an hour, or they weren't too uh, willing to play a game where let's say if they had 5 minutes to themselves during the day, they didn't want to spend it playing a video game, and that was fine. So it was taken into account of just this is a supplemental approach to helping place the legal principles in a more everyday context that is not the leading or the primary source, but it was just a way to supplement the class to complement what we were discussing and put it going from a class discussion where it's more of a rigid is very much a traditional lecture style rather than a seminar format, just between numbers and spacing. But it did help kind of uh, put that information into real world terms that students could then disseminate and absorb at a subconscious or also just at their own pace while they're playing the game. There are some limitations of this, and it was just to be careful of it as using video games as a tool, but also in this context. There's the question about the accessibility of gaming, of what kind of games are you assigning? Are they related to the class? Can they be justified? Or are you just asking students to play Call of Duty or FIFA as one example? And then having some arbitrary inclusion of the legal pedagogy behind it. I felt with the Pokemon Go example, it was a wide enough game. There are a lot of elements that we've touched on as a result of the design of the module, but also designed in relation to Pokemon Go that would kind of prompt some discussions of students. There's a question about the time and the cost of using video games. Not every student will have the availability or the resources to play the latest game. So low stakes, low effort games can be beneficial here, where everyone can do it. They can play it on their phone. It's not a costing game, but these games can be free. They may have microtransactions, but that's a separate issue. But they are free to play. They're not a burden on the student, and they're not a time burden on the student where you are assigning to play the game for hours. There's also the limitations of the study, that the broader engagement with the community of the game. Some students had been quite active in playing Pokemon Go, and their experiences would be very different. But it's about how they're viewing it now, as opposed to how they viewed it while they were playing it, where it came out a couple of summers ago. And this is where students, where this Pokemon Go is at 6 or so years old, they were playing it when it came out. They were in their mid-teens, but now they're in their late teens, early 20s. They have a very different mentality, and some of them had noticed and commented about this in class of how certain decisions they made as a child or as a teen more so, they would look back and go, maybe I shouldn't have been so cavalier or so willing to accept these terms and conditions. And there was a question about the ethics and privacy then. If students are uploading this to personal information to the game management system, can we compel them to do so? So again, this can kind of go to how the selection of the game is important. Of if you are requiring students to sign up for additional services, can we do that? Can we obligate them to do so where there's a risk of failing or not fully embracing and engaging with the class material? So again, there's the limitations of which video games can be used. It is about open access games, but also where there's a question of intellectual ownership clauses of can the student, if they do create a viral video, can they be used as an advertisement? And just ensuring the students aren't giving away too much information or too much rights in a very broadly written user license agreement, because they have to do so for their assessment. And the early results, this assessment is still due. It's still ongoing. It's due at the second week of December. But an overall, some student feedback has been that it has been successful. That it has helped students reflect on the abstract topics that we've looked at, like what is privacy, how does your data work. Many students had questioned their previous engagement with user and end user license agreements. Did they have to click the I agree button? Did they actually read the terms and conditions, as well as the privacy paradox of social media, where they want to take part in this, but they also want to protect their privacy? Do they upload information about themselves playing the game, or are they more cautious about what information is being put up? And some students had some comments about the predatory nature of games and microtransactions, where they're aimed or intended to be aimed at minors. So Pokemon Go, it's based on the Pokemon series. It's aimed more predominantly at a younger audience, even though older audiences are the equal aspect of the demographic. But where there's the predatory nature of, do you need to engage with the microtransactions? Are these targeted minors? Should more protections be put in place? And particularly where students had played this game, where some of them were younger, so again, the mid-teens, they were still minors, and now they're adults. the microtransaction and loot box elements were some consideration, or that elements that gave them pause. And I'm hoping that where the rest of students submit the results, there will be a continuation of this overall success, that they did find it beneficial. It wasn't just an exercise for the point of an exercise. It did help them to kind of put the topics in place, to help them to gather the thoughts. And the reflective nature of the journal, rather than it being a traditional research essay on Pokemon Go, does seem to be helping them to put themselves in the place of the topic where they may have struggled with new ideas of privacy, new ideas of data protection or data rights. So overall, it looks to be a success, but we'll see how the overall moderation goes. Thank you for your time today.